honor and privilege to be speaking to this august audience. Sincere gratitude to the committee of the association for inviting me. Honestly, I don't know, looking at the audience, I don't know how competent I am to actually discuss this because, most of you all are far senior to me than I've ever, probably you've been practicing way before I was born for some of you all. And at least I have consolation, some were batchmates of mine. But what I actually plan to do is, I don't know, it's called a lecture series and I'm really grateful for it, but I think it's going to be more a discussion. I want to share more things, because over a period of time when I've been working with the government of Maharashtra on the enforcement of this law, so in fact we were pretty much working with them on the rules and everything, and then subsequently being amicus to the Bombay High Court in the Suvamoto PIL. A lot of things emerged, and then consulting to various bodies over the years, 2010 to now, it's a decade and a half, a lot of things have developed and a lot of problems have surfaced. A lot of complexities have also come into place with all of this. But of course, there have been a lot of solutions that have been created because of this act. It's made it's made life a lot easier for senior citizens. So let's explore that. I'll quickly go through the act. I really don't want to go through much of the technicality because we are all lawyers and we're familiar with most of this. I would rather want to spend more time on discussing gift deeds and the enforceability and implication angles of it. Because also, over the years we fought it not only from the point of view of this act, but several other things like revocation of gift deeds. It's also in a couple of matters that we are handling, we've gone into cases where it's gone into partition suits, administration suits, and a whole lot, because gift deeds have been done without due diligence on the title. So because of that, there are a lot of operational issues that come in. Many a times, we as advocates, and I'm including myself in that, sometimes we get carried away with the client and, we feel bad for a senior citizen, or we feel bad for a particular child who's looking after that senior citizen. And sometimes we ourselves get carried away, and then we realize that what we did has legal implications which are not necessarily right, which is why when we discuss these things at a public forum, we actually realize that we need to see these aspects to make sure we don't have these glitches or these technical goof-ups, so that our documents are foolproof, our gift deeds are perfectly valid, and subsequently if our senior citizens need to revoke them as per section 23, we are well within our right to do it. There have been several conflicting judgments on that, most of you all would be aware of. What happens is in those cases also we've had cases where, because a particular revocation clause or the specific provision for maintenance has not been mentioned, gift deeds have been upheld, maintenance has not, and there are several conflicting judgments across the various high courts across various states, and of course different interpretations when it goes to the Supreme Court as well. Let's quickly look at the act. The act to provide for more effective provisions for the maintenance and welfare of parents and senior citizens, guaranteed and recognized under the Constitution, and for matters connected therewith and incidental thereto. That's pretty straightforward, and this was the first time, I think the first time since independence, that we came up with a law, the government came up with a law specifically to deal with senior citizens. Because earlier, except for chapter 9 of the erstwhile CRPC, there was nothing that really dealt with it. Here we had a specific statute that Parliament gave us purely to deal with these issues. So whether it was maintenance, gift deeds, abandonment, it was all set out. Of course, why are we discussing this? Because section 17 bars us from practice, by the way. So officially, section 17 of the Act says lawyers are not supposed to represent these matters, especially before the concerned authorities. However, now over the period of time, so back in 2010 when the law became enforceable in Maharashtra, what happened was we were not really too prone to allowing advocates to appear. But over a period of time, the system started allowing us, and now it's, I think, pretty much most of the cases advocates do appear. As per section 17, no, and the section hasn't been amended officially. But most of the concerned authorities do not object. Certain cases, yeah, certain officers don't. Certain cases, see, again, as a statute, it's not permissible, so legally you're not allowed to appear. But in certain cases where it's been allowed, if it's been overlooked, then well and good. If you're going strictly by the statute, then section 17 totally bars you. So legally, we are not supposed to appear. Like I myself get several requests. I totally do not appear because as per the law, I'm not supposed to, and I don't want to get into that gray area because it's the only time you actually appear is when it comes in writ to the High Court. That's where you require advocates. But where we really fit into the entire thing is, the documentation part, because if we document our transactions for senior citizens well, we would avoid potential litigation. Why the act and the objects of the act, pretty clear. More nuclear families, the decline of the joint family system, more independent families, children residing with parents have decreased. Perspective change that senior citizens are being treated as a burden. Population of senior citizens on the rise. We've seen a lot of cases of abandonment. The NGOs have done a fine job at trying to secure their interests, but of course there have been several cases. The constitutional provisions that support us in terms of the law. So as advocates, when we look to protect senior citizens, most importantly, their right to life and personal liberty, which is, of course, the key area that needs to be touched upon. Because, of course, every life of every citizen is important, every person for that matter. And then we move to Articles 14 and 15, which is the equality before law and equal protection of laws. Again, it's a scope for academic debate. And being a legal fraternity, it's always a matter of open to interpretation, because you'll say if everyone's equal before the law, and in the very strict construction of Article 14, then you'll say why a specific law for senior citizens, because it's actually discriminatory to that extent. But if you look at it across every section, when there are issues, and that will go back to the evolution of law, because if you go back to the evolution of law more from a jurisprudence point of view, why do we have laws that evolve? We have laws that evolve because there is a specific necessity, because there's a specific need. When there was chaos, there would be a need. Like you see what happens during the classic case is the IT Act 2000, because post the millennium turn, when IT systems started stabilizing, the use of information technology drastically increased. Now with the increased use of information technology, it was expedient in the interest of justice that a law be created to regulate this business. Which is why when e-commerce came in, you had the e-commerce rules that came in pre-COVID. 2020-21, you had the OTT and special guidelines under the IT Act, the rules 2020 that got notified in 21. These came in because, see, as OTT, back in the day you had television regulation. OTT came in, surpassed that regulation. There was a need to regulate them. And as systems evolve, as society progresses, there would be new circumstances that would come in, which is where then the need for legislation comes in. So with increased cases of abandonment, with increased cases of harassment of senior citizens, security threats to senior citizens, there was a specific need to protect them, which is why when you look at it from an academic perspective, a specific law was created. The definitions are pretty straightforward. Children, as defined under the Act, maintenance, food, shelter, clothing, residence, and medical attendance and treatment. So it's not only food, shelter, clothing as per the basic necessities, but also medical treatment and attendance. A parent, both biological and adoptive. Again, please see all the judgments on adoption, because there are a lot of viewpoints on that. Relative. Again, this concept of relative is, quite broad, because it's not only the legal heirs. Where there are no immediate legal heirs, it extends to a person. So generally, when we explain it, it's basically, when we say relative, it means a person who's ordinarily, under the laws for the time being in force, entitled to inherit or to succeed to the property or the estate of the deceased. Now again, there's a good question, because if you're going by the laws of inheritance and the concept of spec succession is, you're an heir apparent, but what if the senior citizen bequeaths his or her property to somebody else? So that's always a risk. And then people are worried about, I'll do all I can for that senior citizen, and then he or she will just turn around and bequeath it to somebody else. And then what happens to me? Okay, so there are so many issues that come in, and this is why, this law, people need to be sensitized to it, in the sense that you have to look at it from both the perspectives. You also need to be fair to both the sides, because like when we looked at maintenance, which I'm not dwelling upon too much today, maintenance sometimes can become a very taxing burden, because if I have parents who cannot maintain themselves from their own income, and I also have grandparents. Now, if my parents can't maintain themselves, they obviously can't maintain their parents. It's logical. Now, as relative to my grandparents and child of my parents, I will be obliged to maintain 3 couples. Parents, maternal grandparents, paternal grandparents. At some point, what is the load that I'm going to take on in terms of maintenance? And then would I have enough to maintain myself after that? So, that these are questions that are going to, bound to arise. So it's, as advocates, when we deal with these issues, it's paramount that we actually are sensitive to all the parties involved. Sometimes, it's a natural tendency. We tend to get carried away because of the seniors, because of their age, we tend to support them. But at some point, you need to follow a realistic approach. And you see the judgments that have emerged, most of them do follow a very balanced approach. Senior citizens are those above 60. The good thing is parents do not need to be 60 to claim under the Act. Any parent can claim against an adult child. The procedure is simple: file an application. There are forms, fill it, submit it. The authorities, someone was asking me, I think this gentleman was asking me about the authorities. The authorities are the SDOs. You have one at Bandra East, that's for the Mumbai suburban division. You have one at the collector's office that handles the city, the island city. And then every region would have a subdivisional officer. So they're basically the additional collectors for Mumbai city, for the metropolitans. And for everybody else, it is SDOs. The procedure followed is generally the standard procedure. So it's a hearing, parties are given notice, and finally there's a maintenance order. Interim orders can be passed. There are provisions for interim orders. Who can make the application? Party in person, through a registered organization or NGO. Court can also take suo motu action. Suo motu action has been taken in several cases. Many a times when newspapers and the media highlights issues with respect to a particular person, senior citizen couple, or any senior citizen that's affected, there have been several cases where the system and the courts have taken cognizance by themselves. The purpose, and I'm going to do this, sorry, one second. If you see the last point here, this makes it easy by the system allowing people, and that's the whole thing of section 17, which is right after this, is by making it very simple. Simple forms, simple declarations of your income, your means to satisfy your own requirements, your inability to do so, and therefore the need for maintenance. It's a simple do-it-yourself form. The whole point of this is to avoid complex litigation. So it's a simple do-it-yourself procedure where a senior citizen can go to the SDO, get a form, fill it, submit it. There'll be a hearing, basic principles of natural justice applied, and you'll have an order. As compared to, and this was, when we did the workshops with the organizations and with even individuals at large, what we realized is this was a major advantage. And honestly, I didn't see it as an advocate because, being in the profession, we take these things for granted. But when people came back and said, this is so much easier because going under CRPC, you need to know the code, so generally you're appointing an advocate to move before a magistrate. By the SDO taking it up, quasi-judicial proceedings, very simple. It becomes, and which is why, coupled with section 17, it's very easy for a senior citizen to go ahead and do it himself or herself. We've already done this, so I'll go through the next. Section 23, which is the crux of our discussion today. When can it be void? This is a look at the section. So the main crux to this, the general gist of this entire section is if a senior citizen makes a gift with the condition precedent that the child or the donee or the person receiving the gift, whether child or relative or otherwise, has to maintain that person. At any point, if that person ceases to maintain the donor can move before this authority and set aside the gift deed under section 23. But with making gift deeds, there's a lot of due diligence that we need to do as advocates, which, that's a point that we need to consider. 24 is abandonment. Again, that's an annexure and an extension to 23, because apart from the maintenance provision, there's also the whole question of abandonment, and abandonment has been expanded to a very constructive concept of abandonment, not merely throwing the senior citizen out of the house, which is also a clause which I'm going to deal with when we do the draft gift deeds. Because what happens is, quite often, after the gift is done, for a year or two, I'll very diligently look after the senior citizen, and then I get greedy and I'm like, okay, I want to put that flat on leave and license, or I want to sell it or get rid of it, and then I land up abandoning the senior citizens. Abandoning in the sense, maybe I just dump them in an old age home or push them onto the streets. There have been several cases where senior citizens have been unfortunately pushed onto the streets because they've gifted their property in good faith, and then the donee of that very property has thrown them out. Which unfortunately is, also what we need to look at, is because when we do these gift deeds, we need to document this into the gift deed. Otherwise, if we don't, a gift deed is absolute. So you give me a gift, thank you very much for the gift. Now, no thank you, please do not stay in my house. And then we have a problem, which is where we need to look at this. There's also another big angle to gift deeds, is because of the issues that we come in. Let's take a look at what gift deeds are. I mean, we all know that anyway. Section 122, Section 123. Gift deeds need to be documented in a proper format of a gift deed, and very importantly, need to be registered. It has to be a registered instrument under the Registration Act, with stamp duty and registration fee paid. So even if it's to your immediate child and you're getting the rebated stamp duty, you still need to have it registered. There are many cases in which gift deeds have been done on 500 rupees stamp paper with 2 witnesses, maybe notarized but not registered. It becomes a massive issue when it comes to enforcement, both for the senior citizen as well as for the child, even if there's no problem with the senior citizen. Because later on it becomes, of course, as we all know, encumbrance on the title. The title is not clear. These are the kind of clauses that we generally put in. But before we get to that, as when we advise clients, there's another whole issue that we take up, is whether do you want to really gift or do you want to bequeath? Because a lot of the HR professionals, a lot of the retirement planning professionals advise their clients, and I have also advised clients in several cases, it's better to retain the property for your lifetime up to death. Thereafter, bequeath it to whomever you want, be it your child, be it some other relative, be it a trust or a welfare organization, or whatever the case may be. That's up to the will of the person. But the point is, you at least hold it till life. When you gift it today, you don't know what's going to happen tomorrow. But, there are cases where people say that, okay, I have 3 children. And we've seen this as well. So, we have 3 children, and I want to give it to child X, because she's been the one or he's been the one looking after me, and he'll continue to do so till my death. And if I make it under a will, there is a possibility that that could get challenged in terms of a testamentary suit. So if I do it as a gift deed in my lifetime, I will save my child the litigation of going through a TS. So it's a rational perspective, and it's perfectly justified to both the sides, because it's perfectly fair to preempt potential litigation. You may make a bona fide will, but yet someone may want to challenge it. And yet, at the end of the day, if you're securing your rights through a gift deed as far as your child is concerned, you also have to be concerned that you don't lose your own right in the process. Which is where these terms could probably, to the larger extent, save us and save our clients more. Which is also where we first of all say that the child or the donee who's receiving under that gift deed would be required to maintain us for life. And in the event of a breach of this clause, I am entitled to, or I am at liberty to move the courts under Section 23 of the Maintenance and Welfare of Parents and Senior Citizens Act to have this gift deed revoked. So that makes it very clear it's a condition precedent, because without that condition precedent, it can always be argued that no, that was just purely given as a gift out of natural love and affection. There was no implied condition that I needed to maintain you. Because there are gift deeds happening in the general sense of the term, not only between parent and child, but even between, one spouse and the other, or between siblings or whatever, where there is no maintenance or any other provision as a condition precedent. It's just a pure gift out of natural love and affection. So in that case, there is no binding clause. So when there's this intention to bind the person by maintenance, it's necessary that we incorporate that into the gift deed. And the other thing is, especially when it's a flat where the senior citizen resides. Now, if it's a second property or a third property, it's a different thing. But if it's the parent house in which the senior citizen resides, which in most cases it is then all the more necessary that you put a clause that I'm gifting you the flat today, but you will allow me to reside for the residual portion of my life, basically until death. So that you cannot argue later that you gifted it to me. Once you've gifted it to me, it's mine, and now I don't want you to stay on my property. I'm sorry, but you'll have to leave. Because that's very unfortunate. It's happened in several cases, and parents have given their kids property in good faith, and then unfortunately, in not that good faith, the kids have thrown them out of their own house, which is probably their matrimonial home, or maybe even a generation before that. These are the things that we need to look at in terms of the due diligence, because many a times we get documents and we say, okay, I'm the owner of the flat. Before making a gift deed, because these have been challenged in partition suits and administration suits, where, for instance, and spes succession is being heir apparent, what happens is you may be an heir apparent, but it's coupled with a whole lot of things of owner. I'm going to get into all of that. Section 6 of the Transfer of Property Act, both in terms of nemo dat quod non habet as well, because many times the gift exceeds the portion that is actually owned. And I'll explain this to you with an example. For instance, Mr. X, being the husband, owned the flat. Mr. X passes away, leaving behind a wife and 3 children. Okay? Mr. X also expired intestate. Mr. X filed a nomination saying that in the event of my death, my wife is hereby nominated as the member of the society. Society, based on the nomination, files its forms, takes its affidavit cum indemnity, registers the wife as the member of the flat. That is strictly as far as the membership is concerned under the Maharashtra Cooperative Housing Societies Act. It is not governed under the Transfer of Property Act. Because the Transfer of Property Act, when read with the Succession Acts or the personal laws applicable, assuming Mr. X was Hindu, the wife would be entitled to only 25%, because it would be total number of legal heirs and property divided by that number. So 3 children plus wife would give each of them a 25% entitlement or an inheritance of 25%. Now, when the wife makes a gift deed, she shows the share certificate. On the basis of the share certificate, gives the entire flat to child 1, child 2 or child 3, but only one of the children. What happens in that case? The children are still entitled to the 25% under the law of succession of the father's share. This has happened in a recent case. I'm, in fact, in litigation on that matter, where the wife and the husband own the flat jointly, which means we assume it was 50-50. The wife has gifted 100% to one child. Now she's entitled to 50%, and it was a Christian family, so 1/3 of her husband's estate. 2/3 of that 50% is still the children's, which could not have been gifted. It's now before the courts. So this is, the kind of sensitivity that we need to look at when we are talking about due diligence. We need to understand that, ownership of title is different from membership. Just because you've complied with the society membership, it doesn't mean you've complied with the title. Unless you have a release deed or a probate or any sort of document that establishes title, your title has not been passed on. So if your title doesn't vest with you, and that's why I said nemo dat quod non habet, because that is the crux of it, where if the donor does not have full title vested in himself or herself, then the gift itself is voidable. So this is where your nominee and beneficiary comes in. Because there could be a nominee, there could be spes successionist, and then there could be a legatee under a will. So ultimately that legatee is the beneficiary.
this example, if not the 100%, at least 50% share the wife is entitled, then the whole document of gift deed will become invalid or
So you'll have to go and get it declared in court. Then get a court order, then carry out a deed of rectification to rectify the gift deed to the extent that is permissible. Because if she's entitled, so she will be in the case, in the second example that I gave you of the Christian couple, in that case she would be entitled to 50% plus 1/3 of her husband's estate. So that would be 1/6 of the total property. Now what happens is that percentage will have to be arrived at, and then you'll have to get an order from the court in terms of administration of the estate, and then get a deed of rectification carried out to amend your gift deed to only the extent that she's in a capability of. Then administration suit. Then administration suit before the High Court.
But in case if there are only wife and the son, and they get the headship certificate, where the son has given an obligation to favor the mother, but then the mother writes a will, she can also specify that the 50% of succession is already of the son, and I'm only limited for 50%.
In a will, you can do that, no? If you're gifting it. So we're doing it from the point of view of gift deeds. So she can either gift her 50% and say that my son is the other owner of 50, and therefore, pursuant to this gift, he will be the absolute owner of the property. That is fine. In a will, you could do the same thing like you rightly suggested. But I'm talking of cases where the title was not fully owned, and then I'm gifting the entire property to you. So I can gift only to the extent that I own. I can't gift beyond that. And there are several cases. I think we've got about 4 or 5 cases like this lying in office. It's a common occurrence, unfortunately. So,
One query.
sure.
Actually, if that property is a Bhada flat property, husband is expired, wife is alive, and kids are 3 kids are there. But now that flat transferred into the name of wife, means their mother. Children give NOC of that.
See, again, NOC is a very grey area.
If she wants to give that flat to only one child, so in this case, whether NOC of the other child.
I'll explain that, because see what happens is, and let me just skip a slide. Let's go to this, because this would probably help satisfy this issue much better. When you're talking about NOCs, first of all, NOCs do not transfer title. NOCs, the actual purpose of an NOC is only if you're transferring shares in a society. The correct way of doing it in that case would be a deed of release, again registered with the sub-registrar. Because for those who work with banks,
But property is that MADA property. So MADA is
so MADA has its own set of restrictions, but at the end of the day, any title needs to be registered in terms of a registered instrument. Many people do this with NOCs, affidavits, indemnities. The issue is, which is why the focus on membership versus ownership comes into play. Because, for instance, when the husband expired, the last transaction would have been the purchase, the sale deed, between either the seller or the developer and the husband. Correct? Now, for people who've worked with banks and done due diligence on loans, you all are the experts on this. You all know way better than me that a bank will not accept this kind of a transaction, because what is the last registered document? Until you don't have a probate, until you don't have a letters of administration, until you don't have a release deed or some document which is either from a competent authority in terms of a competent court of jurisdiction, or the sub-registrar of assurances in terms of a registered instrument, you do not have a registered transaction. And then if you go back to the Registration Act, the Registration Act is categorically clear from day one. A property above 100 rupees of immovable nature has to be registered. So all your NOCs, affidavits, indemnities, notarized documents, letters, all of these do not hold weight in terms of, because even section 123 is clear, it needs to be gifted in terms of a registered instrument. So until the document is a registered document with the sub-registrar of assurances, that document has no value in the eyes of law. It's legally not viable nor binding. So in such a case, it's going to create a problem. And in fact, if it does not create a problem for the senior citizens, let me tell you this, it's going to create a much, much bigger problem for the kids. Because if, I know, with all due respect to both the sides, the senior citizens as well as the children, if it happens during the lifetime of the parents or the parent, you have the parent to rectify the document. You can always file a deed of rectification. But unfortunately, that mother giving it to her child has passed away, and now the child wants to sell it, or the builder has come in for redevelopment, and your paperwork, your title is not in place. That child cannot procure his mother's signature, cannot have her before the registrar to file a deed of rectification, because unfortunately his mother is no more. Whereas, which is why I'm saying, if it happens during the lifetime of the senior, it is much better because we can fix it. Deed of rectifications are possible, we can go ahead and do something. If the main parties are no more, how do you do it now? That poor child is, literally tied, he's bound. So it's always better to stick to pure registered documents, strictly stick to the law, because it's not only about the present generation and securing the senior citizen, but assuming everything goes off well, it also secures the child after the lifetime of the senior citizen. Otherwise, what happens is, you're exposing that poor child to risk, and then he has to run in circles to clear up the paperwork, run to courts, run through a whole lot of documentation processes just to legitimize something which is actually rightfully his or her. Which is why, that due diligence of special succession is membership versus ownership. Your title is very crucial. Understanding your title before you gift it. And then, of course, is revocation. If there is a breach, especially of the two conditions we spoke about earlier, then your option is move an application before the maintenance officer, the SDO, and have it revoked. You'll have to move for enforcement, and if not, then move to the High Court. No, because unfortunately the SDO is an authority and doesn't fall within the ambit of Section 2C of the Contempt Act. I totally agree. See, also what happened was, I fully agree with you, because I'll tell you, it's not like I'm blowing hot and cold, okay, but at the time when I said, maximum of 10,000, and when it came to a question of maintaining parent plus grandparent, and at that time when salaries were, 25,000, it was a heavy strain on the children as well. But today, with 10,000 rupees, you won't even be able to do a complete blood workout, because if you have to go for a medical, your bill is way over 10,000 with any decent hospital in Bombay. See, there is a proposed amendment. The amendment bill is in Parliament, to the best of my knowledge. We hope these things have been covered up in the amended bill. Again, it's up to the good conscience of the officers, because when the officers actually look at it, there have been cases where they've extended a bit. Hopefully, it's always a case, because at the time, now see, even the registration provision, when you look at it, immovable property of 100 rupees and above needs to be registered back in 1902, as in you could get a lot of property, because that whole law was 1902 to 1907 that it was drafted. Between 1908 is when it came into force. Even as of 1908, 100 rupees was a lot. Today, I don't think we get a square nanometer for that price. 100 rupees, I don't think we get anything in Bombay. The appellate authority, again, it depends. The appellate authority goes to the collector in cases. Deputy collector. Is collector. For gift deed of declaration before the sub-register. The Act itself allows for execution. So, there are provisions under the Act itself. In terms of appeal, I'll get back to your question, sir. In terms of appeal, again, at the time, even when, back then we thought the appellate provision under Section 15 was universal, but the appellate provision under the Act is very strictly if a senior citizen is aggrieved by the order. which is why if children are aggrieved, the only option is remedy in terms of writ before the Honorable High Court of Bombay, for us at least.
If the senior citizen is agreeable,
Then appellate authority,
what is collected? And after that,
then writ. So senior citizens have the option of a single appeal. For children, there is no appeal. There is no appellate provision under section 15, which means the only option is then 227.
There was one case which I had where the senior citizen wanted to give the property to the son. They made a big deed, they registered it. But then they said, we won't go to the society to get the membership transfer. Till date, it is not transferred. What happens in that case? The son is looking after it. But the property is not transferred till date because the senior citizen doesn't want to take.
See, in the pure sense of the term, I mean, that is not an issue under this act nor under the Transfer of Property Act. But under the law of cooperatives, I'm not an expert on cooperative law, but according to me, to the best of my knowledge, the society should take an objection because technically the membership goes with ownership. And if the ownership has been transferred, it is necessary that the owner is brought in as a member. So if by gift, the ownership of the flat has been transferred, it is but obvious the membership in respect of that flat. Because society, especially housing societies, the membership is purely based on the flat ownership. I can't become a member of your society if I don't own a flat in it. So if the flat has moved hands, then it's obvious that the membership needs to go to the owner. Whether it's mother and son or, parent and child, or whether it's a third party purchaser. It's like, I sell the flat to you, you buy the flat, you're staying in the flat, but I keep the membership because I want to use the swimming pool in the parking lot. That is ridiculous. Because there are judgments to that effect also. Parking allotments as well as society membership only can be passed along with the flat. So when the flat transfers, it is obvious that everything transfers with it.
No, my question is, suppose the son, now the parents have passed away. After 20 years, he takes a 50 and goes to the society. There, what happens?
He can still transfer it.
He can still go.
There's no limitation on membership.
Right, so it's safe. They don't even transfer.
But the sooner it's done, the better. Why do you want to, sit with illegalities on your head? I mean, if you've got something to clear, you might as well clear it off. Because, see, you never know. I mean, everything is evolving. Tomorrow there is a different statute. Tomorrow there's an amendment which doesn't allow it, which puts a cap on the transfer time. That child will be stuck. Then when it comes to NOCs for sale, redevelopment, all of that, you're going to have massive problems.
only for cancellation of property is only the civil code threshold of provision for cancellation rules. In case of cancellation of this decree, this aid and supervision, then we can go before this authority and not before the civil code.
This is only under section 23, the authority has the power. But that specifically, cancellation is only to the extent under section 23 where the gift was made by a senior citizen in favor of a child with the intent of maintenance.
So it is only in this circumstances if the gift is made, it can be cancelled before this. Otherwise,
No. All other instruments would go before a regular civil court. Because again, this is a statutory body, so it cannot override the CPC and the general laws of the land.
before this authority, CPC limitation nothing.
Limitation as per the Act, yes. So CPC, I mean, the Act states its own procedure. To where it is silent, of course, the generic law would take effect. So to fill in the gaps, of course, the CPC would come in. In terms of the criminal provisions, as of the time of the Act, the CRPC did come in. Now, of course, it would be the BNSS, as the case may be. These are some of the judgments. The most commonly cited is, of course, the Urmila Dikshit judgment, because that overruled the previous ones, and it's very clear. So there, of course, there was no express clause, but there was a promissory note. So even if you've taken an undertaking in terms of a promissory note or an undertaking which has been annexed with the gift deed, but if you're doing something like this, at least this is my personal opinion to things and my viewpoint from the understanding of the law. If you're taking a promissory note, as in this case, or you're taking an undertaking of sorts, please annex it to the gift deed as an annexure, so it goes into the sub-registrar's office as a document. Because if you take it as an extraneous variable, it becomes very difficult to establish later. Sorry? To the extent of her parents, yes. Father is married for the second time. And see this, the child is liable only to that person's parents. I am not liable to my stepmother. Because step parents are not. In the absence of the husband or the wife, yes. So if it's a widower.
Still, I'm liable to maintain my father.
Change the slide.
I'm done. Yeah, so thank you, I'm done.
Wife is alive. And she's not working. She doesn't have a leave. So am I husband is liable to maintain the mother-in-law, father-in-law? That is my question.
See, in-laws are not covered under the act, okay? But the question that comes in then is if the child is not available. Like for instance, a case where the parents are there, the wife has expired or the son has expired. The son-in-law, the daughter-in-law, as the case maybe, would be there. Now that person would be ordinarily entitled, and that's where your question of relative comes in. That person would be ordinarily entitled to the share of that deceased spouse. So in that case, if I am entitled to the share of my wife who is deceased, then I am liable to her parents. But if my wife is alive, she is liable.
It's like where there is a right.
See, I myself have honestly, on a very serious note, I have not understood this complexity of in-laws, which is why I have stayed away from marriage, okay? It kind of baffles me a bit to that extent. So I have kind of successfully navigated my way out of marriage. So let's not comment. Because there are people who are watching it live that may have an objection to that. I don't want to be in family court tomorrow.
Stepmother does not have a child and the stepson is liable to the stepmother.
To the extent of the inheritance received from his father, yes.
So if the father is also alive,
Then she can go on the direct.
I have my biological father alive. I have a stepmother. Am I liable to my stepmother for inheritance?
Under the act, no.
What was the alternate remedy prior to the enactment of the 7th law?
Chapter 9, section 125 of the Code of Criminal Procedure.
Again, to question number 1 now,
Which is why you had this act. I think one of Sir mentioned rightly. What was 10,000? Oh, you mentioned, I think. But what was 10,000 back then? I mean, it was a lot then, but today it's of little or no value. At 1973, when the CRPC came in, 1,500 and 1,000 was a lot of money. Today, I don't think we'll find an advocate to move an application in that kind of money. Let's not get there. that would take up a lecture in itself.
So basically, Floyd, what is actually saying, who's liable to maintain the parents is where you have the rights, where is the duty. Like if you have the legal.
Because a stepchild is also not, a stepchild is not directly liable to inherit the estate of the step-parent. Now, again, that's why, earlier when we spoke about adoptive kids, I didn't get into that because there's a lot of things. Now, if there are several dimensions to that. If the step-parent has adopted the child, then this entire discussion doesn't happen, because then, of course, that child is as good as a biological child. For all purposes of rights, not only maintenance, but also inheritance. Now, if you go into Christian adoption, that's another gamut which I can spend another hour on lecturing, because that's a whole different ballgame. There is the manual, what is it? The manual Theodore D'Souza judgment. She's the one handling that case, so she knows it better. So, there are so many things that come into play. So,
So senior citizen executes a gift deed in favor of his son. Now, it's by virtue of that gift deed, he becomes an owner of the bond. He gets a membership transferred. Say if it is a case of flat and suicide. He gets a membership transferred, he becomes the owner of that by virtue of that. Now, he sells or transfers, sells that flat to somebody, somebody suicides. Now, subsequently, he is not maintaining his parent, then they want to revoke it. Both is section 23. Then what will the
so that is again up to your drafting that comes in, and also because there are several issues. Even worse than that, forget the sale. There have been cases of people disputed, say, because at that time you gifted me a flat which was X. The building went into redevelopment. At that time, I'm not a donee because I directly signed a PAAA with the developer. So in that case, you'll need to mention also that the flat either is not sold until my death, or the other option is, in the event that the flat is sold, the proceeds of the sale to that extent is mine and can be attached. Because what happens is, if you gift property X, X is sold, and with that money he buys property Y, this clause can be defeated in that, saying that you gifted me X, I allowed you to reside in X till I sold it. Now I bought property Y with money from the sale proceeds of a property which I sold, which was already gifted to me. Therefore, it's my property. Sale deed is between developer and me. I am not liable to maintain you, which is then in the case we need to. So that is why when you sit with your client, we need to discuss all these things. That's why you need to sit and ask them, what is the possibility? How does it work? Are you anticipating your building going into redevelopment? In that case, you also have to make a mention of the flat that would come in permanent alternate accommodation. So all of these things have to be factored in, which is why it's always better to sit with your client in terms of a conference or a meeting and discuss these nuances before preparing the gift deed. What many people do is like, gift deed is a simple document. Say, okay, take the details of the property, give it to one junior, type this gift deed, send it out. It's not wrong.
Conditional gift is very so many conditions you are looking at the big amount of gift.
See, under section 23, it's condition, but it's condition for maintenance. It's not a condition precedent. So it doesn't become a voidable condition.
But you cannot sell it. This money will come back to me. So many conditions.
You can't say you cannot sell it. But either you'll have to say that if you sell it, then this thing, or you cannot sell it till my lifetime. After that, you can. Because at the end of the day, gift is absolute and forever. If you're not transferring the property absolutely, then you're not transferring the property at all. So then you'll be going into violations of provisions of the Transfer of Property Act and several other laws that will, become grey areas again. So then it becomes like a conditional bequest in terms of testamentary, where you only have a life interest and not an absolute and final binding transition.
So it will not be a proper transfer interest.
No. So under section 23, which is why you need to also specify, like you saw the rough clauses that I put in, it very clearly says this is for the purpose of section 23 only. So for all practical purposes, it is a bona fide gift deed. Because if you put condition precedence, that this will take effect, or you say that the sale is possible only on the happening of a future event or whatever, then these would all be barred by the laws of transfer of property and general contract law. So in every respect, it would be barred.
So should we put this condition or what?
Condition for maintenance, condition for residence, definitely.
But not to sell till my lifetime. Will it be a proper
See, if you're saying not to sell, it will always be preferable to say either not to sell or in the event of sale, allow me to reside in the newly purchased flat with the proceeds of that flat. And if not, then with you. You can block them to the extent that you will have to give me residence till my death. That can be done, for sure. See, putting blocks on sale, putting blocks on total restrictions, that would then, of course, as you rightly pointed out, defeat the purpose of the gift deed. Which is why I then said, it's always better to will it rather than gift it if you're anticipating these problems. Because then at least for your satisfaction, the senior citizen is in ownership of the property till his last breath. Thereafter, he or she will go. You see, but then of course you have the flip side to testamentary proceedings. If somebody challenges that will, it goes to court, you're stuck in years of litigation. That risk also exists. So you have to weigh the pros and the cons. Again, it also depends. Like, where we've had these families which are nice, happy families where you don't expect trouble, we say will it. Where we are anticipating a problem, we would say, if you're forced to give gift. But that I totally agree with you, because in fact a lot of the times the problems have surfaced after the demise of the parents. As long as the parents are there, the siblings are kind of holding on, and then the day the parents are no more, that's when things change. The family dynamics change, which is very unfortunate, but it happens sometimes. 1 sec, I'll just take my answer. It's not advisable. It's a statutory requirement, ma'am. Any gift deed, section 123. Document which is required to be registered is not admissible in evidence if it's not registered. Registration Act, very clear. And section 123 of the Transfer of Property Act very clearly says a gift deed needs to be in terms of a registered instrument. People say a lot of things. Like, people tell me I should not go to a doctor, but I'll have a lot of problems if I don't go to a doctor.
Best example of Vijay Singhania.
There's so many cases. I mean, that was of course one of the.
Yeah.
See the bigger cases, I mean, where the estate values are very high, and also, when there are people of that stature, you have it all over the news. But there are so many people, from the upper middle class, and just people like us who are having, the same problems, and where it hurts them as badly, if not worse. But because it's just one of us, you don't see them every day in the news. One sec. That gentleman's been waiting. Sorry, sir.
I've had revocation, and the time limitation was 3 or 4 years before something happens to me, and I was with a bill. This is a valid bill because I cannot make a bill of property which are already revoked. What is that?
It's up to your drafting. So when you draft your will, you say that I am currently, but that's if you've already filed proceedings under section 23. So when you draft it, you mention specifically that I have currently initiated proceedings in respect of this flat under section 23 of the Maintenance and Welfare of Parents and Senior Citizens Act. In the event that the gift deed is revoked and the flat is then brought into my name, the said flat stands bequeathed in the name of so-and-so, whoever, second child, third child. Yeah, but it will be a valid will, but then it will have to be disclosed. It's like how you disclose future properties. You can bequeath future properties. And of course, you can make as many wills as you want. So you can make that will for the time being, and then if your order is in your favor, you can always... Correct, so that's how you do it then. Make it as a provisional that when it comes to me or if it comes to me. So we also do this in case, when we have disputes going on properties. I am entitled to an ancestral property. The matter is sub judice before X court bearing, suit number so-and-so of so-and-so. In the event that this is decreed in my favor and I am entitled to this property, I bequeath my share in that estate to X, Y, or Z, absolutely and forever. No, it would generally be understood to the extent of half. But then it's always better because it's all up to you in terms of how you want to draft it. You can always say, I mean, I'm entitled to this much, but or to whatever extent has passed by the Honorable Court. See, Mr. Kadam behind you is already envisioning how to draft these things. It's not invalid, but then again, it's all subject matter of interpretation. Someone wants to go to court. Someone wants to challenge the clause. And remember, it's a will. When you go for probate, somebody files a caveat under the Rule 401 of the Bombay High Court rules. It goes into testamentary suit and then... Sorry?
And the civil law, the request is not due to X, but it can't be.
It will be covered under the residual clause. But if the intended bequest was to somebody else who's not the person receiving under the residuary clause, then you could have a problem. See, it's all a matter of how you construct, which is why I tell people, see, many people, especially with wills, wills, everyone thinks, oh, I'll download a template off the net. Now the new thing is AI can get me a will. And even, when we've done legal aid centers and legal aid cells, people have said, so there are templates which we've given people. But, at the end of the day, they just fill in the blanks. There is no application of mind. When you go to a lawyer, that advocate is going to apply his or her mind. There's going to be a whole thought process. There's going to be a rationalization of how to build and construct that document. There's going to be a whole lot of activity that goes into it before it goes out to you as a final document, which is what clients ask you, why so much of fees? But they don't realize the amount of hard work, the amount of thinking that you need to put in before creating. That will maybe just 2 or 3 pages long. Because that's how it works. There's a lot of thought process, there's a lot of thinking, reasoning, rationalizing that goes behind creation of a document.
Which definitely prevailing there. This transfer of property or succession. If suppose there is some dispute, because nowadays what all children have no same nature. Some may acquired by giving some false assurance. Under this, if other children are challenging,
We don't see challenging the will or challenging the gift deed.
challenging,
Gift deed will be purely under the maintenance and welfare if you're challenging under section 23. If you're challenging a gift deed in general, it will be 122, 123 of the Transfer of Property Act read with section 34 of the Specific Relief Act.
but there is no specific for which act will do it.
No, it is very specific.
It should be read along with other act.
If you're going under the maintenance, it goes with no other act. It will go strictly under section 23, nothing else. If you're going in terms of general gift deeds, not using the maintenance clause, in that case, it will go under 122, 123 of Transfer of Property. To declare it void, you'll have to file read with section 34 of the Specific Relief Act. Because Transfer of Property Act does not give you provisions for declaratory orders. So your declaration, your relief will comes in terms of your Specific Relief Act. So that's how you'll parallel in terms of the operating of both statutes.
So that is like
That is not applicable in these cases. That's applicable in general gifts when you're trying to rescind a general gift deed. But if you're going specifically under the non-maintenance provision, the 122, 123 of the of TOPA does not apply because you go strictly under this act. And again, going under this act, the advantage that you have is this is a specific authority, so it's much faster, it's simpler as compared to going to a civil court. The purpose of this provision is to basically avoid the long-run litigation, which is why we have this statute. I mean, thanks to
Section 24 specifically is not applicable.
section,
24 of specifically.
they will declare directly under section 23. They have the power to declare under section 23. The authority doesn't have, because only certain provisions of the CPC and CRPC as of this, I mean, which mutatis mutandi would apply to the BNSS, would apply to them as per the Act. So the Act, for certain provisions like for examination of witnesses and certain provisions like for arrests and other things which have been given, only those limited provisions from those statutes have been incorporated into this as per this. But for everything, it's the same as consumer protection and all the other laws. Like, for the purpose of these sections or this chapter of the CPC is applicable.
So there is no evidence, cross-examination, nothing of that.
They will go as per their statute. So there are general principles of natural justice followed, but it will not be the strict evidence that is followed in civil courts. So if you're expecting that, very strict evidence rules that we follow in courts, that won't happen. But yes, there will be evidence, there will be examinations if required. Again, the SDO has the jurisdiction to decide if he wants to allow examinations and to what extent, whether by way of affidavit or by way of an actual examination in terms of cross and examinations in chief. Okay, before that, I just want to thank a few people who all You can take a bow. I mean, I have to thank you as well. Yeah, of course, the main man behind it all. I mean, of course, I have to thank the honorable judges of this court, I mean, who, of course, unfortunately couldn't make it, but many of them consented to come in. The association for the very kind invite, Mr. Naqvi, our honorary secretary, Mr. Jadhav, our president, whose blessings I always have. Thank you so much. Ms. Anisha Narayan, joint secretary as well. Keep this presentation in order because honestly, I saw the presentation, I think late last evening for the first time. There were a lot of additions that I'd asked for, and it's all those people at the back that had that piece in place. Vedika, Angela, Tanishi, Dia was busy shooting, and the whole lot of the guys back that make sure these things happen very successfully. Our tech teams, creative teams, and all the guys that help us keep all these events documented. And hopefully, if everything has been recorded fine, we should have a video link of the entire thing up in a few days. So hopefully by next week, I'll have the link sent to the association, and it will be available for all who couldn't make it. And of course, thank you to each and every one of you, all our dear colleagues and friends who've taken time out of their busy schedules to make it. And for those of us who couldn't make it, who'll join us on the video links when they're out. Thank you so much.
Thank you.